Gormagad Lascan Carla, Erdús, Boalam, couple focal raw, Mayalam, Hallam, or a Hertig, on Quivne is sportul at all gum, Egmi Hall, no Clihi, in Najagan is an oka hen, Idabalo Clia, Agus on V, Nakera, Clihi, Shin, Agus is Queen Lum Coma, couple blino hen, Vishe, kind to Shim Satira, Drawley, Gumprod, Lumfain, Gan Nota, Be. Agus Vishe go on a Vishe go hunta car fad an Quidne is mo at all gwim agum Mariola Mihal no son cloher an dangen godjig blian o hin imi na nolog agus Vishe an shomar daddy na nolog agus Vishe kindle Bertlani a chaile ahar agus Vishe cocanalta codas agus có smúl lo go raibh an tailech an a bhuiach ar fad agus cinnte ní bheith eile héad a rí seán. I'll formally move this the amendment and we're going again with another report which recommends obviously renewal of the Offences Against the State Act, but 4 years on from the decision of the former Minister for Justice to establish an independent review group to examine the Offences Against the State Act, we have the report but no consequential actions have been taken. The group consulted widely and took submissions with the Bar Council, on Garda Síochána, a UN Special Rapporteur, the ICCL, Oireachtas, EPP, academics, and indeed from Sinn Féin we submitted submissions of our own. Such a review was also a commitment made during the Good Friday Agreement, which stemmed from a recognition that a period of armed conflict north and south was coming to an end. The legal legacy of that conflict needed to be dealt with, and a structured approach to dealing with the past is a non-negotiable part of conflict resolution and reconciliation. The acts were meant to be in response to an emergency period which was declared as over in 1995. So the question must remain, do the government still believe that this emergency continues, or are they picking and choosing from what is politically expedient? Sinn Féin recognises that there remains some need for legislation similar to the Offences Against the State Act, and that's contained also in both the minority and the majority report of the review group. But it's not sufficient to use this as an excuse to delay the recommendations in the reports. In 2021, our Oireachtas passed a motion that affirmed our position that the court is anachronistic and called for a modernisation of the law. The motion also noted the remarks of the UN Human Rights Committee, which has stated that the trying of civilians by these non-jury courts should be very exceptional. We also believe that the use of any non-jury court must be compliant with international human rights standards, set a high bar to on the exceptional circumstances to be met, and to be subject to judicial oversight, and also to involve independent human rights oversight to protect the integrity of the process and the human rights of any person tried before such a court. It's over 2 years since we made the submission to the review, and as well as the need for more modern legislation to address the threats to the security of the state from organised crime gangs, and this includes assessments such as the risk of cyber attack. The members of the group must be wondering, and I'm sure they definitely are, why they put so much time and effort into a report, and as they feel that the government is sitting on the report. The relevant sections are renewed year after year, and the Special Criminal Court, which was reintroduced as a temporary measure in 1972, has become a permanent feature of the criminal justice system. This was reviewed in 2002 by the Hedderman Committee, and that committee recommended new legislation and repeal of the Offence Against the State Act, yet no subsequent proposals were introduced. Last year, the majority in the independent review group recommended repeal. So is there going to be another 20 years of waiting before simply another review is sought? I note that from your engagement today, Minister, that you said that you intend to engage with relevant stakeholders in relation to jury reform, but that should be done so that we can modernise the criminal justice system. This debate is somewhat like Groundhog Day, as the Oireachtas should not be discussing the renewal of the legislation again. It's a missed opportunity. The Minister is bringing before the Dáil measures which are outdated, legislation some of which is rarely if ever used, and measures which you know need improvement, and meanwhile not bringing forward the sort of reforms and improvements demanded and recommended by the expert panel which the government itself established on foot of our calls for change. There is a need for modern legislation to address the challenges facing communities and the state in relation to organised crime. Of course, this debate is not just about the Special Criminal Court, but an oversight procedure of whatever form should be introduced, whereby the DPP must justify her decision to prosecute there in every single case. The exact form of which needs to be proposed and debated in committee and in this chamber. It's easy to say that cases of jury intimidation is a reason for referral to the Special Criminal Court, but it should be clearly and objectively outlined. That's a given. And there should be a reasonable apprehension of jury intimidation and how safeguards are unlikely to work, and that should be stated. The DPP should also maintain statistics in the exercise of this, and the issue of statistics and that in relation to all crime, especially as we heard earlier on today in relation to domestic and gender-based violence, is not, the lack of statistics, should I say, is not confined to this area, and we lag way behind neighbouring jurisdictions in our compiling of data in order to manage this Defence Against the State Act legislation, but also gender and domestic violence. The principle of equivalence in the protection of human rights under the Good Friday Agreement should support harmonisation of standards of human rights protection and accountability, but this has not transpired. So the Special Criminal Court continues to operate, has actually increased activity over the years, and it's obviously hearing criminal cases which are not associated with armed or proscribed groups. This, of course, is this is another example of inactivity by the government. The implementation of the COFP has not occurred. There hasn't been enough diversity introduced to Garda Síochána. That, as I said, for domestic and gender-based violence hasn't been compiled. There is 9 counties with no domestic violence refuge, and the legal aid threshold for women in particular who are seeking legal redress is way too low. The risk of business as usual for offences against the state is continuing on indefinitely. Now, it suits the government to do as little as possible and then blame political opponents for the issues that arise. The proposals of both reports should be considered in more detail, and if the Minister is consulting, we need to see what is being said. In the meantime, we'll have another year where communities face the scourge of criminal gangs and Gardaí feel under-resourced and underappreciated. The most recent expert group in essence recommended the same thing. There's no legal reason for it to continue, no operational one and no moral one. So I'm calling on you, Minister, to implement the recommendations, listen to Gardaí, listen to communities like those who are outside the gates today of people whose families had died from drugs, invest in community drug teams and clinics which have been starved of resources, and listen to the community projects if you're serious about tackling crime and also the fear of crime.